All right. Hi. Hello, everyone. Hope everyone is doing great. And thanks for joining us for today's session on strategic intellectual property management for startups and entrepreneurs as part of the PIER71 Explore series. My name is Gao Ming from the PIER71 program team. So just sharing some background about PIER71 for those who might be hearing about us for the very first time. So we are a joint collaboration between Maritime and Port Authority of Singapore and NUS Enterprise to establish a vibrant maritime ecosystem in Singapore. We run programs and events that are designed to provide maritime-focused startups with access to markets, resources, investors, and many more. The PIER71 Explore series is a supplementary learning series offered as part of the PIER71 Accelerate program, which is a 7-week-long mentor-guided market validation and customer discovery program. The program is attended by many of our finalists of the 2021 Smart Port Challenge, and in fact, most of us here in attendance are actually our challenge finalists. So for today's session, let's welcome Dr. Jack Cheng, who will be sharing more about the analysis of intellectual property and its impact on business technology strategies. Dr. Cheng is a Principal Assistant Director, Head of Greater China, and faculty member at IP Academy, Intellectual Property Office of Singapore International. He also holds an appointment as Adjunct Associate Professor in the NUS Institute for Engineering Leadership. As a certified patent valuation analyst and senior IP technology consultant, he also specializes in IP policy, patent analysis management, competitive intelligence, and innovation management. All right, now without further ado, over to you, Dr. Jack Cheng.
Okay, thank you. Thanks for your introduction. So hello everyone. So it's my pleasure to see you online virtually. Due to the pandemic, so we cannot see all of you guys face to face. But if you have any questions about IP or even patents, feel free to drop me or any of our colleagues to email. I'll be happy to help. Okay, so let's start our session today. Okay, yeah. So the topic today I'm going to share with you guys are strategic IP management for startups and entrepreneurs. So actually, as Gao Ming has already mentioned, I'm also holding a associate professorship in IEL. So this is also the reason why I'll be happy to share with all you guys about that. Okay, so before I officially start, actually I'm also holding a position at the IP Office of Singapore. So that's the reason why, as a government agency, actually we provide a free consultation session for all of you guys. So in the end of the session, I will share with you in IPOS, we do provide a IP legal clinic and a business clinic as well. So actually, we will arrange a lot of lawyers as well as a business consultant to help all of you guys in relation to any IP issues. And the first hour of the consultation with lawyers and business consultants will be fully subsidized by IPOS. Okay, so this is a very, very good opportunity for you guys to approach the right expertise and IP professionals you can bring with your own questions and problems so far, and they will be happy to share with you guys. Okay, so this is totally free for the first hour. But if let's say you have any further questions for your subsequent consulting hours, you can arrange or discuss with the respective consultant as well as lawyers to do that. Okay, so don't worry, I will share Gao Ming with the link, and you guys will know how to do that later on. Okay, so what I'm going to share with you guys today is to talk about the IP management, especially the IP value chain, and how to use IP to control over the whole supply chain. Okay, because when it comes to patent or IP, so IP considered as a general term of different types of, let's say, patent, trademark, copyright, and confidential information. So in short, based on our scenario, most of you guys may deal with some of the situation like patent, because patent is a way to protect your technology or to protect your innovation. Okay, so this is considered as an IP value chain. The second one is what's the impact of IP on industrial process, right? So if let's say if we are the owner of the IP, you actually have 5 rights: make, right to make, use, sell, offer for sale, and imports. So actually, our 5 rights will be given as to the patent owner. Okay, what does it mean? It means that if you are the owner of the IP, you have freely rights to enforce all these 5 rights. On the other hand, if you are not an IP owner, if you would like to use the technology or the innovation protected by patent, it means that you have to get the protection or the permission, the consent from the owner of the IP. Otherwise, you are not allowed to use it. Okay, so this is the way of doing it. And I will use some of R&D and the business intelligence use series as a case to share with you how to extract the relevant information from patent data. Okay, this is because the patent data will help you guys to save a lot of time. Means that when you have an innovation, you have a technology, right? You have to disclose all these technical technical advancement and the technical advantages in order to get the protection from the IP office. Okay, so that's the reason why you have to disclose all the relevant information to the public. And then in return, the government will give you 20 years of monopoly rights. Okay, the philosophy of the patent system is to encourage everyone to disclose their invention or technology. And in return, then the other people no need to reinvent the wheels. Means that everyone can tap on what you have already done to do some further analysis, further technical advancement. So this is also the reason why don't only look at the journal article only, but also to look at the patent database as well. Because based on the statistical data released by World Intellectual Property Office organization, over 80% of the technology only released, okay, in the patent database. It means that if you only check the journal article, only about 20% of the information can be found. Okay, and also I use Apple and Samsung as an example, talk about patent portfolio and the litigation, and some of the patent strategies. Means that if they say you already figure some of the patent, how to design around, how to discuss with the relevant stakeholders in order to get the permission of the patent owner to do that. Okay, so this is roughly I'm going to share with you guys for today's session. So as can be seen from this diagram, as can be seen from here, so the brown side of the bar chart means that in 1975, only 17% of the corporate value is from intangible asset. However, if you look over about 20 or 25 years, it's already about 2015, almost 84% of the corporate value are from intangible assets. Okay, think about that. Previously, what's the most valuable asset to the company? If you read that back to 1980s or even 1990s, usually it's the factory, the equipment. But nowadays, if you look at the most valuable company, let's say Google, right, Amazon, the most valuable asset of the company is the intangible asset. Means that the talent, the software, the algorithm, okay, or even the system, the platforms. So all these type of value or the asset only can be protected under IP. So that's the reason why if you want to secure the value of your company, how to deploy a patent strategy or IP strategy is very, very critical and indispensable in the course of your company growth. Okay, so this is the reason why. And also, as can be seen from here, the intangible investment has surpassed the intangible asset. So not only the money, but also the value comes from intangible assets. So I would like to share with you this. This is a smartphone competitor patent suits. So this is Apple, and this is Samsung, right? So the arrow means the direction of the arrow means Samsung actually sue Apple, and Apple sue back. So there are a lot of litigation among the smartphone industry. But in fact, in short, not only limited to smartphone industry, but also in almost every high-tech related industry. Think about it. If you say you have a smart port, right, or you have used a lot of software, there are definitely a lot of litigation involved. So what does it mean for you guys is that when you do a coding, right, you have to make sure your source code, your software is not infringing any of others' software. Okay. Otherwise, if you say we are quite used to it, right, we just use Control C and Control V, right? It's copy and paste, right? Actually, it's not allowed to do that because all the software, all the source code are all protected by either copyright or patent. So you have to bear in mind is that after you come up with your idea, you have to coding, right? You have to find a relevant types of IP to protect yourself, right? Protect yourself is to protect the advantages of your company. Okay, so that's the reason why, as can be seen from here, they have a lot of litigation among all the giants. Okay, so Apple and the patent trolls do their little dirty work. So as can be seen from here, in the embryonic stage all the way to a maturity stage, right? In the very beginning, IP is considered as in the very beginning, IP is just considered as under civil law, right? It's a property law, and under that it's an intangible property. Okay, after that we have a uniform standard or uniform codes, try to harmonize to be more comprehensive, to provide a one-stop solutions for all of you guys to solve all the relevant IP issues. Then after that, it's become a legal instrument. What does it mean for you guys? It means that if let's say I have a patent and I know Gaomi is going to introduce, Gaomi is my competitor, and Gaomi is going to introduce a new product. And I don't want Gaomi to be in the market. Why? If Gaomi in the market, he would like to share the profit, right, with me. But I don't want to. I want to increase my entry barrier because I'm already in this area. What should I do? Then I use IP or patent as a legal weapon, try to prevent Gaomi from entering into the current market. Okay, this is very, very common. So as you guys as entrepreneur, please bear in mind, it's a very, very important thing for you is that usually all of you guys are technical savvy and you have a lot of good ideas. But you can forget the rest of the information I share with you, but don't forget this. Okay, just 1 or 2 points need to bear in mind is that when some big company would like to invite you guys to share your thoughts, the first and the most important thing is don't forget to sign the NDA with the other party. NDA means non-disclosure agreement. Because you are in a comparatively weaker position, or even just be frank, you have no bargaining power with others, right? All of the big guys say, okay, Gaomi, I know you are an entrepreneur, right? And please, I'm interested in your information and in your technology. Can you share with me? In the very beginning, as an entrepreneur, we are quite happy about that. But bear in mind, if let's say we just share our thoughts without any legal protection, what will happen next? What will happen next, right? In reality, is that if let's say Gaomi share all his thoughts to me, I will say, oh, Gaomi, okay, thanks for your information. It's quite helpful. It's quite fruitful. And then 6 months later, I will come out with my own products. Why? Because I'm more resourceful than you. You are just an entrepreneur. And you have nothing can do because you have no legal weapon can help you. So the first one is to always to sign a non-disclosure agreement when you talk to the big guys. Secondly is if let's say include any of the material, right? It's a material transfer agreement. You need to sign 2 of these to protect your idea and then your materials and the information. And what if the big guys or the other parties still breach the contract or breach the agreement and they do their own things? What can you do? At least this group of people breach the NDA they have already signed. So you can come up with the legal actions. Okay, you are not, we can say you are not naked, right? You are armed. You are not naked. If you don't sign anything, you are naked. You can do nothing about it. Okay, so this is very, very, very important. This is the first one. And the second thing is that if you are growing bigger and bigger, you may inevitably to collaborate with external parties. When you collaborate with external parties, how to define the ownership of IP, right? In the very beginning, we just, it's okay lah, Gaomi, two of us are very good at chemistry. We just work together, try to figure out everything to try to come up with the invention first. This is not right because I have dealing with a lot of litigation cases. It's between the inventors, especially from different companies. So have to make sure the ownership of this technology or the ownership of this patent before you allocate any resources into it. This is very, very important. So this is the 2 things I would like you guys to remember. First one, as an entrepreneur, usually we are shortage of resources. So NDA must sign. Okay, material transfer agreement must sign before you disclose any of the technical issues with the other party. Second, the ownership. Okay, the ownership of the invention. This is very, very important. Please bear these 2 things. Okay, lastly, if the other party don't want to sign, okay? And you still want to attract them, okay, to impress them, to start the next step. What should we do? The third one is don't tell the most critical steps to the other party. You just share the overview of it, the outcome of it, but the way to achieve the outcome, please don't disclose. It's not we hide something, just like we haven't built up the trust, right? If you trust me, cannot say it's trust. Trust is okay in the real business world, doesn't mean anything, right? You have to sign something before we start the collaboration. Okay, it's not like in the university, right, where you will see a lot of nice mentor. We don't set up the trap. We just try to sincerely to collaborate with you guys. No, in a real practice, it's not like that. Everything talk about contract. Next thing talk about the rights and the liability first. We settle down all of this, then we do other things. So the third one is don't tell everything. If you have 10 steps to achieve the ultimate goal, please only share the first 3 or 4 steps. The rest you keep in your heart. Okay, don't tell anyone until the other party sign NDA or MTA. Even the other party outsource, allocate a source of funding, you disclose gradually. Don't tell anything everything in advance, because not only entrepreneur may make this mistake, but also a lot of professors will do. Okay, professor will stay in campus. No offense, but we just share what I've been through, have dealt with before. Is that a lot of professors, when you discuss with some of the big companies, or professor, oh, prof, this is innovation is very good. Could you share me more? Wow, the prof tell you everything. Okay, in the end of the day, as a result, nothing happened. The other party, the other company introduced a new product right away. Okay, yeah. So this is the common pitfalls or common traps a lot of entrepreneurs are suffering, okay, are being suffered. Okay, so this is what I would like to share all of you guys. So how to solve this issue? Number 4, IPOS. We have business clinic and the legal clinic. The first hour of consultation is free to you guys, but we still need to, as a government agency, we still need to pay, right, to the lawyers. Lawyer may do things for free, right? Lawyer or the consultant. So this fee will be subsidized, absorbed by the IP office. But we have an business clinic and the legal clinic to do that. Okay, so this is 1, 2, 3, 4. These 4 things. You can forget the rest of the session today, but this is the most important things for you guys to remember. Yeah. Because I'm not a technical expert, I cannot give you some professional knowledge about how to develop the technology. But it's from legal side of the house. This is the step 1, 2, 3, 4 you have to bear in mind. Okay. Yeah, so let me introduction to IP. So what is intellectual property? Intellectual is IP commonly refers to the creation of the human mind. Okay, so IP is protected by law. It gives rise to IP rights. So what are the 5 rights? Make, use, sell, offer for sale, and import. Okay, so IP law gives legal rights to IP creators, allowing them to control and to exploit the use of their IP for a specific period of time. Okay, exploit it means that if let's say I'm the patent owner, do I need to manufacture by myself? Not necessary. Okay, means that I can manufacture by myself. I also can license out to Gaoming, and Gaoming can on my behalf to manufacture. For example, Gaoming is specialized in manufacturing and they have very high yield rate, so I may outsource to him, but I'm still the inventor. I'm still keep the title of my invention. Okay, and the layer IP for a specific period of time is if I'm the owner of the patent, I have the IP protection, patent protection for 20 years. If I'm the owner of the trademark, right, I have the protection for 10 years. But for trademark, as long as you pay the maintenance fee or annual fee, the patent is the trademark is renewable perpetually. Okay, so this is some of the difference I would like to share with you guys. And everyone can take a look about this. I don't know whether still can. Okay, I think it's okay. So can you identify the relevant IP rights? We have a patent, right? Patent is to protect technology. Trademark is to protect the brand. And the copyright is what? To protect the drawing or even some of the literacy works, and also some of the confidential information, right? Some of the critical information I don't want to share with you guys. The other party, I just keep it as a confidential information. So what are the most well-known two examples? The first one is the formula of the Coca-Cola, right? Coca-Cola was combined by 4 critical elements, and only some of the specific person know. The rest of the guys, we don't know the combination of the Coca-Cola. The second one is KFC, Kentucky Fried Chicken. I think most of you guys are going to would like to have a fried chicken, right? So I also would like to have. So KFC, if you see the slogan of the KFC, it's tasty, and this chicken was include 24 or 25 recipes, but they won't tell you what exactly the percentage of this 24 recipe. They will keep it as a trade secret. So as can be seen, this is a copy machine, right? So usually this can be protected under what? Anyone can type in the Q&A. Ali, you want to share? Or Andrew? Okay, so this one usually can protect it under, let me check, trademark, okay, or even a trade name. And then this is also the register design. So it means the configuration or the shape of the products can be protected. Even the bottle of the Coca-Cola is protected under trademark as well, because the shape, the angle is different. Okay, and then this is the patent method of extracting coffee from a capsule. Okay, the way is a technology, right? The way how to extract the coffee from a capsule is also another one. And also patent trademark is for the capsule per se, right? This is the design and also some of the blueprint. So you can do this. And the rest is the confidential information. It's the blended or a blend of ingredients. Okay, so because in the capsule, they will only share with you is what is what are included in the capsule is the sugar, right? Is the milk, is the coffee, but the company doesn't show you how many percent is from coffee, how many percent is how many sugars and how many milk. They don't tell you. This is considered as confidential information. Okay, after the combination, they will hide it, all the information, but the test is very good. Okay, so this is roughly, so the main purpose of this slide is to share with you actually patent or IP is involved in our daily life, almost everywhere. It's not very far away. Okay, so a lot of people just, okay, I just focus on technical technology development. I don't care the rest of the things. I let a legal person to handle it. But unfortunately, IP is not like this. When we talk about a patent, right, this is a technical to protect technology. Can you expect a lawyer without any technical background to understand what you are talking about? This is very, very difficult. It's also unfair to a person who helped you to draft the patent. So usually it's like you are an owner of you are the inventor. You have to prepare, the next step is to prepare the technical disclosure. Then after that, you have to discuss several times back and forth, many times with the patent lawyer. And the patent lawyer will help on your behalf to draft the patent. Okay, so this is the very, very important things you guys have to bear in mind. Cannot just say that, okay, patent is a legal document, I don't want to spend time on it. No, this is totally wrong, because no one understands your technology better than you. You are the only person, usually the only person who knows the best. Okay, so I've seen a lot of real cases is that the technology is very good, but when we convert the technology into the patent, it's terribly written. Unfortunately, when the other party use your technology, or we say infringe your technology, who is make the final decision is the judge. When judge refers to your they don't refer to your technology, they refer to your patent. If your patent is well written, the scope of your patent can fully cover your technology, then it will be perfectly fine. Okay, If cannot cover, then the other people can just use for free. I just share with you another real cases is the thumb drive. Okay, anyone have used thumb drive already? Yes, right? So for thumb drive, usually have the pattern is written like this. We have a movable instrument, okay, movable device, and then we have a fixed device. And then these two devices were connected through a wire to transfer the data. Everyone knows that, right? The movable device is the thumb drive per se. The fixed device is usually the desktop or the laptop. The transmission line is the line, right? Line cable, then can transfer the data. So actually they have three elements. Okay, so the pattern is written like this. So back to nowadays situation, the current situation, is it anyone use a thumb drive is a infringement or not? Nowadays we still have a fixed the device, right? The laptop. We still have a movable device, which is a thumb drive. But when we transfer the data, transmission the data from the thumb drive to the laptop, do we need a wire to transfer? We don't need, right? We don't need to. We just plug in the USB port and the data can transfer directly. So we just fulfill 2 out of the 3 elements. We don't fulfill all of them. It means that there's no infringement. So I don't need to pay anything to you guys. Okay, so this is a typical cases that this is a good invention, but the patent is terribly written. So the patent cannot protect the invention. But when we talk about infringement, we only and solely refers to patent document. Don't tell me how good the technology is. I don't care. Patent is a legal document. So what's the lesson for all of us? Is that if you are an owner, you are an inventor, you cannot only focus on technology per se. You have to discuss, to communicate with the patent agent, the patent lawyer, to come up with a better patent. So this is in the subsequently, if you say someone really use your technology, you can use a patent as a weapon to protect yourself. So IP is an intangible property. IP can be assigned, licensed, or pledged as a security. Okay, so IP can as a third party. IP is territorial in nature. So if you have a patent in Singapore, you only can get the protection in Singapore. Okay, if you want to go to Malaysia but you don't file for patent, what will happen? Means any people in Malaysia can use your technology for free because you don't file patent in Malaysia. So what does it mean to you guys? There's another question for you is that after you come out with a very good technology, you have a patent. The second question for you is where to file my patent, because patent is territorial. Okay. If you guys, how would you make the decision? Because we all know that file patent is very, very expensive, right? In Singapore, if you want to draft a patent, to file for a patent protection, one patent is right about 5K to 10K. If you would like to file a relevant patent in UK, it still also have a 5K to 10K, but the currency you need change to pounds. This is very, very expensive. So everyone just tell me, oh, Jack, I would like to file as many countries as possible. The second question I will ask you, how deep the pocket you have? You don't want to waste too much money, right? So you have to decide where is the place to make your product. Where is the place you try to do your R&D? Where is the place you want to sell to? And the last thing is that which country is the possible counterfeit products that may come from? So usually this is the 4 factors you need to take in consideration. Why? This is very straightforward. Go back to the 5 rights given to the owner. Is make, use, sell, offer for sale, and import. So when you decide the territory to file your patent protection, usually is the place you make. Where is the market is the place you use. Okay, the import is that if you figure out another counterfeit products manufactured in the third countries, another country, you file a patent there, you can stop them from exporting to another country. Okay, so this is roughly the area I would like to share with you guys. And IP can be overlap, means that a trademark over a trademark design, the coffee machine may be protected as a registered design, and the method of extracting coffee can be protected by patent. Okay, so one coffee machine comprises of various types of IP. Okay, even the software I believe some of you guys already heard is that some of the patent software can be protected under copyright as well as patent as well. Okay, so roughly it's a patent to protect the invention, trademark protect the sign. Okay, confidential information is the Coca-Cola formula, non-public and valuable information, and the valuable information, and the original and the related works. And we also have other types of IP, but we just bear in mind have different types of IP. But usually the 4 types of IP is copyright, patent, trademark, and the confidential information. Okay, some of the patent types of IP are registrable, some are not. So for trademark, patents, and the registered design is registrable, means that you have to register through the patent office in order to get the protection. Okay, this is very, very important. And then not registrable is the copyright. Okay, copyright will enjoy the protection when the time you finish your works. And the confidential information is protection of non-public information with value. Means that you have a certain measurement, certain method try to protect your confidential information. You cannot just say that, okay, we will see a lot of document, right? Open accessible document. There's a watermark say confidential. Okay, is it considered as a confidential information? Not really, because it's not only you put a watermark say confidential information, then this document is considered as a confidential information. No, you have a certain measures, means that only a limited limited people can access this information. You have a password protected, and you have any other measures try to narrow the scope of a person who can approach this. Then this information can generate business value. Then this information can be considered as a confidential information. Okay, so this is also very important for you guys. Anyone would like to make a guess? Which one is iPad? Which one is Samsung's iPad? Is the left hand side is Apple or right hand side is Apple? Okay, as can be seen from the apps, right? It's very easier can be seen here. But if you only can see the shape of the pad, right? It's very difficult to tell the difference between Samsung's pad and the iPhone's pad. Okay, so this is the one, Apple's iPad and Samsung's iPad, and this is iPhone, and this is Samsung's phone. Okay, so this is lost information, or this iPhone or iPad actually protected by the registered design as well as the patent. So when Apple introduced this product, and Samsung would like to, can I say copy, you want to imitate, actually Apple filed a lawsuit against Samsung on this on infringement. Okay, so this is how powerful the IP is. And in the end of the day, Samsung tried to reach the settlement of the court with Apple. So it means that Samsung every year have to pay a huge amount of royalty fee to Apple in order to get the permission of Apple to use the shape of the design. Okay. So criteria for a patent. So we have a novelty, inventive step, and the industrial applicability. Okay. So these are the 3 criteria. I may not dig into it, but I will just let you guys understand what's going on. And the novelty is absolutely novelty. Means that it's not similar to any previous invention. Okay, and the detail of the invention should be kept confidential before application. You are not allowed to disclose any of the information before you file for patent protection. This is very, very important. Okay, we used to have a lot of professors, and those professors would like to share their research results before file for patent protection. Then the tragedy is that they are not allowed to file anymore because it breached one of the criteria, is absolutely novelty. Okay, this is a real example. Steve Jobs' original iPhone keynote video is to invalidate Apple's patent in Germany. Okay, what does it mean? It means that Apple filed a patent application for a bounce back effect in photo gallery in June. So we have a lot of photos, right? When we use these two, we can enlarge, right? If we double click, the size of the photo will bounce back to the original size. Okay, so actually this is considered as a patent. Okay, so not only a very high-tech technology, but also a single one also can be protected under a patent. And the state, but they only filed patent in June 2007. And the Steve Jobs presented the technology to the public in January 2007, which is almost 5 months earlier than the patent protection. What will happen? The patent invalidated because disclosure predates filing date. Okay, so this technology becomes a public goods. Means no one can file for patent. Everyone can use for free. Okay, so this is also very, very important. So another rule number 5, we have 1, 2, 3, 4, right? Rule number 5 is don't disclose anything before you file for patent. If you really want to disclose, you have to sign an NDA, and the other party have an obligation not to disclose anything to the third party. So this is the reason why rule number 1, sign an NDA, sign MTA is very, very, very important to you guys. The second one is must be different from the state of the art. So the different must be not be obvious to a skilled person in the art. Okay, so the first one should be new, right? In short, it's new. Inventive step is to be new enough. Okay, but how enough is enough, right? It's very subjective. Unfortunately, I cannot give you a correct answer. This is how you bargain, how you discuss with the patent examiners. Okay, the patent examiner will help you to solve this issue. And this is it obvious to a skilled person? So this is a taxi, right? Taxi LED play, right? So if you say no one, the car is empty, will be taxi. If someone hired, and it will be turned into red, and then the town will be hired, right? This is considered as a patent as well. But some people say a skilled person does not require much imagination. But actually, this can be controlled under a remote controller, right? And this is just a normal LED panel. So the judge said that a skilled person does not require much imagination to connect to the remote control. So means with the multicolor LED display on the rooftop of a taxi. Okay, so this means that it's not inventive enough. Okay, but I have done several times of survey on this invention. Usually 50% of the guys will say this is good technology, should be protected under patent. Another 50% of the people say, what a big deal, especially if you guys from engineering school, they will say, what a big deal, this is just some of the two basic function and they come up with this invention. So what does it mean to you guys is that sometimes the inventive step is very, very subjective. It depends how you argue it, how would you be able to discuss with your patent agent, and the patent agent will on your behalf to submit application to the patent office, and the IP officer will help to examine and to back and forth several times. And what are the patent IP system is we have a patent company, we have R&D, then we draft the patent, and we usually will hire law firm to do that because this is a legal document. Then we'll submit this to the patent office. And the patent office will try to have we'll get a patent. And the patent you can license out, right? Just mention that I can license out my invention to government. I don't need to manufacture, or I don't need to make by myself. And you have invalidation. If other people without your consent and they try to manufacture something, you can do the infringement. And we have government agencies to try to help you to protect your rights. Okay, so this is roughly the patent ecosystem. So we have a patent analyst, strategy consultant, valuation specialist, try to measure the value of your patent or the value of your IP. And the last one will be alliance. You can join alliance. And within the alliance, you can exchange a lot of information with your stakeholders or with the other party, try to come up with some of the new inventions. Okay, so why we need to read and analyze the patent? The first one is try to avoid to reinvent the wheels, right? The other people has already done, and the other party has already disclosed to you guys. You can just refer to it, and based on this, do some further inventions or advancements, okay, or the progression. So you can collaborate with the patent attorneys and understand the IP rights of his own company, understand the competitor's IP. So you have to understand where is your competitor, what are the relevant information or the product has been introduced, okay, to the people, to the IP, and understand the technical trend and the hot start. Understand, okay, this is a hot area. A lot of companies already invested a lot of resources into it. Is it a good area to do to make sure the trajectory of the technology development is aligned with my own understanding? Because sometimes we will just involve what we are good at, but what we good at may not be aligned with the big trend nowadays. And then turn the patent into money, right? It's very important, right? After that, you have to commercialize it, and you have to have a patent first, then you can commercialize it. Okay, so this is a patent journal. We have an inventor, right? Now inventor, we have a patent agent, and then we go to the patent office, then we get a patent. So this is roughly how patent come out generated. So if a makes, dispose of, offer to dispose of, use or import, okay, roughly. And yeah, it's a make, use, offer for sale, sales, and import. So it's roughly the same. So it's highly harmonized among all different among all countries. Yeah, and the similarities and difference between the US and Singapore patent system are already summarized for you guys. If you have time, you can feel free to look at it. Yeah, and then this is a patent mapping, patent ring fence, with a litigation, and how to commercialize it. So you can get a patent for all different types of information, and you can get all the relevant information from the other party, and you can understand what should I do next. Okay, so if let's say I want to do this direction, but I know Gaoming has already filed for patent, what should I do? Either I get the permission, I get a license, I get the consent from Gaoming, I pay a certain amount of royalty fee, or I can bypass her, means that I have to design around. I use other way to achieve the same goal. Okay, so for example, if I would like to go to NUS from my home, and the government has already said, oh, Jack, you are not allowed to walk from a home to NUS because I already patented it. Okay, I just use this as a simple examples. So in the next 20 years, no one can walk into NUS because I already patented it. And then, okay, if you want to walk into NUS, also can. You pay me the royalty fee. Okay, so as a poor person, I don't want to pay Gaoming. Right? I'm a very, I don't want to do that. So I try to figure out another way. Say I can go there by bus, I can go there by driving my car, even I can go there by take MRT. Okay, so this is called design around. So the Gaoming cannot catch me. Okay, because I use other way to do things. So this is also the philosophy of the patent system, is that they want to encourage everyone to disclose their invention, and at the same time try to ask other people to come up with some of the new solution. So in the end of the day, 20 years later, we have many ways to achieve the goal. Okay, so after 20 years, it will become a public goods and everyone can enjoy it. Yeah, and only 90 to 95 of the world's invention can be found in patent document. Over 80% of the technology only disclosed in patent documents. Okay, so this is the reason why you have to not only to look at the journal article, but also some of the patent. Okay, so research can shorten the period of time. Okay, so I'm sorry I'm running out of time, but I will just share some of the most critical things for you, and we can summarize it. Okay, so maybe I just share with you a real example. What should I do, and it will help you guys to come up with your own inventions. Okay, so this is theory. We did a patent analysis for them. So the main purpose of this project, right, is to help my client to understand if he or she would like to invest a certain amount of funding into this area, who should I approach to? Which area, technical area, is already very crowded? I don't want to enter into it. Which is considered new area or emerging area? I would like to bet on my money onto these technology areas. Okay, so this is the one we do for that. So actually, we have a patent document and also a lot of things. So we come up with this patent mapping. Okay, so I think most of you guys are very lucky because you are NUS alumni. I believe most of you guys still have an NUS account. So in NUS, we have a patent database called PIER71. Okay, PIER71. PIER71 is a patent search software, so you can access through a NUS library. I believe for NUS students, it's free. Okay, so it will help you to identify what are the relevant information, and they also can come up with some of a similar map. So as can be seen from here, this is super crowded. One dot represents for one patent. So this is very crowded area. Then this is less crowded area. So they will help you guys to make the decision, where should I put my resources in? and what are the relevant competitors or stakeholders in this area. Okay, so this is the one I would like you guys to understand, and this is very important for you guys. It will help you to make the decision, the R&D decision or any other things decision. Okay, so we'll come up with this kind of different types of pattern map. Will help you to make the decision, and this is the pattern trend, and this is the fishbone diagram. Okay, this is also very important for you guys, especially if you're a technical person. So you have to understand what is the major technology area, what are the sub area, okay, what is the sub of the sub technologies. You must have a map on your mind. Okay, you cannot just say that, okay, this area is very important, but I don't know where I am. I just want to do this technology. This one may not work, may not make sense for the investor as well. They have to give you an overview of this technology, and the patent document can help you to do that. Okay, so we have 100 topics. Then electron device have 13 patents. Touch sensitive display have another 4 patents. Okay, so they will give you a brief idea. If they say today, I will ask, okay, Gaoming, I'm an entrepreneur, and I would like to do touch sensor pad. Okay, I want to do touch sensor pad. Then Gaoming as an investor will say, okay, Jack, I know you want to do a touch sensor pad. They already have 10 patents. Could you tell me what's the novelty part in comparison with these 10 patents? Why do I need to invest you? It's already have 10 patents there. Could your invention or technology solve the problem that the lost 10 patent cannot be solved? You tell me. Okay. A second thing is that this 10 patent represent for 10 companies. Could you tell me what is the advantages if I invest you? Not only the technical part, but also even you come up with this technology, will any of these 10 companies buy your idea or to get a license from you? So it will be very, very practical. Okay, so this is the one I'd like to share with you guys. So in the end of my presentation, I would like to share with you roughly, we have a lot of different strategies. Now, give me 2 more minutes, I will conclude my presentation. So we have different types of patent deployment strategy. So usually as a company, right, a small company, usually we use this as a surrounding technologies. Means that usually we may not be able to come up with the core technology, but usually we are very good at the application of this core technology. Okay, just say that if I say Gaoming today, she has invented a chair. Okay, but the most sellable, the top sell product in the market is the movable chair. Okay, so Gaoming have the patent of the chair. I have the patent of the wheels, and these wheels have attached to the Gaoming's chair, and then we can sell to the market. So the question for you guys is what? Is Gaoming allowed to file to manufacture a mover chair without my consent? No, because she used my wheels. Am I allowed to manufacture a mover chair without the consent of Gaoming? Not allowed also. Why? Because Gaoming is the owner of the chair. But in order to have to sell money to commercialize it, Gaoming and I have to work together, right? Then we call it cross licensing. We reach the settlement, we reach the agreement, and then we sell this to a product. So as can be seen from her, Gaoming's patent is considered as a core, and then my patent considered as a surrounding. Okay, then 2 of us combine together and then make use of this one. Okay, so in the end of my presentation sharing session today is to share with all you guys. Don't forget to sign NDA. After you have a technology, please don't disclose to the public before you file for IP protection, patent protection. If you really want to discuss with your to impress your stakeholder, don't forget to ask them to sign NDA. So this is the 2 major lessons or the rules. Most of the entrepreneurs will make these mistakes. And then last but not least, is IPOS does provide these free consultation services. And I will share with Gaoming in the end of my session. Gaoming can, on my behalf, to share the rest of you guys. If you have any further detailed questions, please make an appointment. And now this is all online due to pandemic, but you can help everyone to do that. Okay, so thanks for hearing today, and feel free to ask me any of the questions. Yeah, thank you, Gaoming. The stage is yours.
All right, thank you so much, Jack, for the very engaging, informative session. So actually, we have many questions from our participants. All right, so I will just go back to the very first question posted by Ali. So he's referring to the ownership. You know, if you're developing something together, you know, for example, working with a corporate to develop a solution. So how then can you actually protect the ownership, as you have suggested?
Okay, so Ali, thanks for your question. This is also considered as a common questions. Usually, before we start, so for example, let's say I want Gaoming. I have some I don't have some techniques, but Gaoming has. So we have to work together. And in the very beginning, I'll say, okay, Gaoming, I would like to, depends on whether I pay the money or I outsource this to you or not. If this is considered as a joint collaboration, then both of us will co-own these products. Okay, but if let's say I'm a rich guy or I have a very deep pocket, I say, okay, I just outsource you, I give you a certain amount of money, and government can come out with the invention and can get the full ownership. So in practice, usually is if two companies work together, first one is depends on who pay for the money. If I pay the money, usually I own the full ownership. Secondly, if either party contribute an equal contribution to this invention, usually we co-own it. But we co-own it may arise some of the problem later on. It's like if let's say I want to sell this product, let's sell this patent to a third party. Am I allowed to do so? No, because government may disagree, and vice versa. Okay, so that's the reason why I'm in practice. I'm not encouraged to have a co-ownership, but in practice, it's everywhere. Okay, so this is what I would like to share with you guys. Yeah, usually another way is that I will give my suggestion to you guys is that you can co-own it, but co-own means that the title is Gaomi and me, but I'm the only person can license the rights, and any of the revenue I will share with Gaomi about that. Don't have two people have the same right at the same time. So usually we prefer exclusive right instead of unexclusive. Because if they say this is not exclusive, many people have the rights very乱. Okay, very乱is very chaotic. It's very乱. Yeah. So I'm not encouraged to do that. So two person can share the title of the invention, the patent, but when we enforce it, just let one person have the full right to enforce the right, and the revenue generated can distribute equally. Yeah.
Thanks a lot, Jack. So the next question that we have is with regards to non-disclosure agreement, NDA. So this is, you know, if you have to give a rating from a scale of 0 to 10, you know, how effective is it, you know, as a legal binding agreement to protect against big corporation, and also, you know, whether NDA is applicable to person-to-person interactions, or is it just exclusive to B2B process?
Yeah. NDA applies to any information exchange. So either B2B, B2C, C2B, C2C. Okay, it's all applied. Okay, so this is the one. The second thing is that it's a legal binding agreement. Yes, this is a legally binding effect. But how effective it is, sometimes it depends. Okay, but usually the big company usually will follow it. Okay, but so this is another question for you, for Andrew, is like, if let's say the other party is just a small potato, even he or she signed it on his company, will they follow it? Okay, so to sign a contract is one thing. How to enforce your right is another. Okay, we have seen a lot of cases it's like, oh, I go to the court and government sue me, and he get a litigation, get a judgment from the court. He said, okay, Jack, you have to pay government back $1 million. I said, government just come to my house, right? I only have a very poor house. I don't have anything. So how to enforce your right? Okay, so that's the reason why NDA is one, but still the most critical thing is that try not to disclose everything you know to the other party. This is the most safest way to do that. Yeah.
All right, so the next question would be, you know, filing of patents via the PCT route. You know, is that a better option for startups with scarce budget, you know, and, you know, when the product or service have global opportunities?
Yeah, so usually when we file for patent protection, this is one. Okay, Andrew, first one, please arrange a legal clinic the lawyer will share with you the details. But in short, I will share with you is that you can file a patent, PCT patent, through Singapore IP office because we are a member of Paris Convention and the WIPO. So you can file a PCT with a very nominal fee first. And the PCT will give you 13 months, 30 months, to make decision whether you want to enter into a national level. So you will file a nominal fee through Singapore IP office. You have 30 months to make decision. So it will give you time, this 30 months, 30 months, 2.5 years, almost 2.5 years, try to find a relevant business opportunities. If you really can figure out it, then you pay the money and enter into a respective countries. For those countries, you try very hard, but no business, you have just closed one eyes. You have to give up. Okay, so this is where you can defer the payment of the patent application, especially for our small potato. We are entrepreneurs or we are startups. Okay, so this is the way it's very important. Yeah.
All right, sure.
Okay.
So next question would be, what's the estimated amount of budget, one should allocate, just to obtain a patent for a particular invention that includes, hiring of patent lawyer, professional service.
Okay, so usually a patent, just I share with you guys. So roughly in Singapore, it's roughly about 5K to 12K per patent filing. Okay, so honestly speaking, not only for big company, especially for small companies, is a huge amount of burden, huge amount of money. So this is the reason why you have to think twice before you file for patent protections. So a good technology is one thing. Another thing is whether this technology have a commercial value. Okay, sometimes we are technical savvy, we just passionate for our ideas. This is the technical efficiency is very good, but let's be more practical, is whether any client may use it. So you have to do this kind of estimation or valuation before you throw a huge amount of money to file for patent. Yeah, so it's roughly about 5K to 12K roughly.
All right, sure. Then the next question would be, how do investors actually place the value on patents, and what about trade secrets?
Okay, so IP valuation is an art and science. Okay, so when it comes to valuation, this is very, very subjective. Okay, so if let's say one patent for big company may be quite valuable, but a patent for us may not be valuable. So this is pretty practical. So, but in short, I still have some standard answer for you. When it comes to patent valuation, we have three methods. We have a cost approach, income approach, and the market approach. Okay, cost approach is from cost perspective. So how much money I spend in order to generate this invention, right? This is considered as a cost approach. Market approach is like when we go to buy HDB, right? How can we determine whether this value is too high or too low? So, right? If let's say I want to buy a house HDB next to Gowning, right? I just go to knock Gowning's door. I say, hey, how much money you sell? You buy? And I just want to more sample size. I go to knock the door of Gowing's neighbor. I say roughly how much does it cost? So this is considered as a market approach, right? I go to the market, how much is cost, and a similar product, how much does it cost? And the income approach is that I just do a projection. So because the duration of the patent is 20 years, so I will do the calculation based on the remaining time of the patent. So if I say another 15 years, I just do a projection, and I will try to figure out the present value of the future income. And this comes as an income approach. So usually we have these three methods to determine the value of the patent. And for trade secret, usually it's very, very difficult to decide, because we don't have public data. But the most well-known cases is the Coca-Cola, right? The Coca-Cola, what's the value of the Coca-Cola? The formula of the Coca-Cola, many people say is several millions, even billions of it. Yeah.
Okay, so a follow-up question would be, what's the difference in the cost of filing, patents in Singapore versus Taiwan?
Okay, so the difference in cost of filing patent. Okay, cost of filing, this is considered as a regular fee. So it means that the patent office will charge you a certain amount of money in order to come out, in order to process your patent. So in short, usually, of course, I think Taiwan is cheaper than than Singapore. Okay, so we have a table of the charging cost in our website, in Apple's website. So all of you guys can take a look how much does it cost. So roughly, I think the processing fee may not change a big difference, but the most important is the patent drafting fee is different a lot. Usually in Singapore, so some other people may try to draft the patent in a cheaper country first, but because not only Singapore, but also a lot of countries can draft the patent in English. Then they will bring back to the Singapore law firm and try to help me to file it and try to do some minor changes. So this is one way can save cost. Yeah.
So it's like so this is also a question relating to patents. So enforcement of patent is actually too expensive for startups. So actually, do legal companies offer this as a service and take a percentage of winning a case?
Yeah. As far as I know, this method we call a contingency fee, right? But based on my understanding, Singapore is not allowed to do so. As far as I know, please correct me if I'm wrong. But in US, yes, you are right. So in the US, it's the most active area in patent litigation. What does it mean? It means that if you figure out someone infringe your patent, you have no money, no worry. You go to find some of the law firm will go to see you and say, okay, Gao-Ming, you don't need to pay anything. Okay, if we win the case, I get a 40% of the royalty fee or the remedies. If I lose the case, you don't need to pay single cents. Okay, so this is quite a mature business model in the US, but as far as I know, in Singapore, we are not allowed to do so. Yeah.
Okay. So next question would be with regards, to developing a new platform, but then which also comprise of similar modules and APIs as another platform. So how can we actually overcome further problems regarding this?
Okay, so the API forms and some of the platform is the software, right? Is it?
Yes.
Yeah. Okay, so you have to bear in mind. So there's another point. Some of the platform they use the open source software. Some is the non-open source software. So you have to understand there are different types of open source software. You have to bear in mind first to make sure you use the open source or non-open source. But bear in mind, if you use the open source software, means that every contribution based on the open source software, you also need to freely open to the other party. So is this what you want? You have to think twice. Okay. Then secondly, when you talk to the software or some other platform, you have to make sure how to say it's easier. Okay, so in short is that you have to make sure whether this is open source software or not open source software first. Second thing is that if you want to patent your software, you have to disclose your source code. Okay, is this why you really want to do that? Okay. The lastly is that software sometimes is considered as a black box, right? You have an input, you have an output, but you don't know what happened in between. So sometimes in enforcement, sometimes it's very, very difficult. So you have to think twice before you make the action. Yeah.
Okay, so we'll take last two questions. So the second last question, it's about the discovery of a novel protein, that will enhance the effect of an existing protein. So the question is it possible to patent, this discovery without identifying this particular small molecule inhibitor against this protein? And the follow-up question would be, if someone files a patent for a drug against this protein for the same indication, does he or she have grounds to take legal action if he or she didn't manage to find an inhibitor?
Okay, so in short, discovery per se is not patentable because you just discover something. You don't have some of the input of the human intellectual inputs. Okay, so means that just like you have a gene, right? You have a certain type of gene. So you have to do something in order to change the genes, in order to cure some of the disease. Like this is patentable. But the gene per se, the gene sequence per se is already there. it's just you are the first one to discover, but you are not the first one to invent, to give some of the intellectual input on it. Okay, so in short, discover per se is not patentable. Okay, you must have some human input in order to get it. And then the second question, if someone files a patent for a drug against this protein for the same indication, if I have a ground to take legal action if I have not managed to find the inhibitor? So usually sometimes if they say some of the genes have a new use, okay, of the existing drug or the new use of existing things, this is patentable. But the protection of the new use will be very, very relatively small. So you have to think about it, whether you want to spend this amount of money to file for patent with a very narrow scope. Okay, yeah. And the last one, okay, I just have the business model. Such a method as assign trips drivers like an Uber car. Okay, so the last question will be, okay, business model per se, yes, it's a patentable, okay, in the US especially. But the business model per se, the protection, level of protection is very, very weak. So you have to apply a business model into a software, then will help you guys to take legal action. Because you cannot say this is the business method, then I have this is business ideas, and I want to sue against you. Because you think about it, if you just, how can you just patent a business method? Means that the other people cannot think the similar method, is it? Because if I think, okay, I have to go to A through B, B through C, this is a method, it's a way of thinking. And if I say I can convert this way of thinking, the business method, into a software, and this software can provide the efficiency of the method, then this is patentable. Okay, you cannot just rely on a business method. Although in practice, in textbook, so this is allowed, but in practice, it's very, very difficult to enforce your right. And I think I managed to find out the link for the business clinic. So I just share in the chat, so everyone can click in. And here is the okay. Let me share screen. Just give me one more minute.
No worries.
Yeah. So this is the one. It's an iPost IP Business Clinic. So if you have any business related questions, you can take your questions, type of expertise, you want IP commercialization, strategy, intelligence, what are the types of concern, preferred date. Okay, we have November 18, November, December, and the required information, and you can submit. And you can our iPost colleague will help you to arrange a meeting so you can kick off your discussion with it. So we have a IP business clinic, and should we have an IP legal clinic? This is the legal clinic. Okay, also for business side of the house, you have the legal side of the house. It will give you some of the idea where should protect, you should not, and how to commercialize your IP. Okay, so this is roughly let as we are all taxpayers, right? Don't waste up our we already pay for the tax. So this is one of the service government actually provide for all of us. Yeah. Okay, I think that's all for today. And thanks for Government's invitation.
Yeah, for a very engaging and informative session. It's been very helpful for many of us. Startups are actually developing unique solutions to address challenges in the maritime industry. So to our participants, as what Dr. Cheng has shared earlier, I'll be consolidating and sharing the links to the IP consultation clinics and also the other relevant resources from this session. So before you leave, please scan the QR code to visit our LinkedIn page and follow us if you haven't done so. We will be posting regular updates on various PIER71 events and programs that are happening. And do also register for our next session on Introduction to Infocom Media Development Authority Accreditation Program to learn how this program can actually help support the growth of your startups and access to various resources. So that will be all for today. Thank you everyone for taking time out to attend this session. And thank you so much, Dr. Cheng, once again. Thank you everyone.
Thank you.
See you.
Bye-bye.
Have a good day. Bye-bye.